we just start the class today with a brief discussion of the tour of the Bill of Rights of Correction on Friday?
It was awesome.
It was awesome. Yeah.
It was awesome.
Other than that,
Want to come back
what did
there?
you learn that you might apply to either this class or other classes? What did you learn that you didn't know before as a law student, Elizabeth?
Well, I didn't realize with the minimus.
That what?
I didn't realize with the minimus that's submitted to the jail that attorneys can make markings on that.
Or can have some control over.
Right.
Not that the attorneys themselves would make the marking, it might be the court, but okay. Explain that, because you know a little bit more about criminal law stuff.
Yeah.
So the minimus, or
the minimus, M-I-T-T-I-M-U-S.
What is that?
it's the document that goes with the defendant when the defendant's transported.
Yeah, it tells the sheriff's department what to do with the person that's in custody.
And I didn't realize before, and I'm still kind of confused about that, Professor Caldas, because I had a class last night, trial court, with Judge Cornetta.
Did you ask him the question?
Well, I did ask him because
He said, what?
it made it seem like at Middlesex that the judge didn't really have much control over making the markings on that sheet, that it was the attorneys.
Say that again?
They made it seem like
They meaning
Middlesex.
Sean McAdam,
Yes.
when Sean was speaking?
Yes.
Okay.
It seemed like the judge, once the sentence is imposed, then the judge doesn't really have any sort of say in what the defendant does once they're doing their sentence, once they're incarcerated.
What would they write on that?
Like to engage in certain mental health or substance abuse programs at the prison, at the jail, to get their GED, to get into a veterans program or something like that.
And that's part of the disposition of the case. For example, when I went through the care and protection procedure with you guys, under 119.26, the judge has certain options, but there is sort of a catch-all that says that the judge can also order, like medical care and this and that. So in the same vein, the parties are agreeing, gee, this person should get some sort of, some sort of counseling or whatever. That's what Sean was saying. Somehow, if you could get on the minimus, then they would know about it. So I'm not sure exactly how that happens, but I think it's as part of the dispositional hearing. Okay, he's found guilty, now what are we going to do with this guy? Well, he's going to do this sentence, but as part of the sentence, and it could be that probation, I'm sure, not it could be, probation would also get involved in saying, Judge, this guy has, a record of the drug stuff. If we want him to be rehabilitated, the best thing for him or her to be would be to do X, Y, and Z. Yeah, so I thought that was interesting too,
It was very
about the
interesting.
minimus.
And Judge Cornetta said that he was like, well, make sure that if you write anything on the minimus, it's on the docket too. He's like, people forget that all the time, and then things fall
Yeah, because
through.
again, the minimus is the piece of paper that goes to the sheriff's department, so then it's not in the docket anymore.
Which
right.
I think it's just, a lot of us were talking about how it's just so, it's nice to see that the new sheriff is taking such a proactive approach to starting all these new programs, and really being aware of the people coming in here and taking them in on a case-by-case basis.
Right.
And looking at them, like a lot of them obviously have these suicidal thoughts and feelings when they go there and they're doing a year or two long sentence. So it was a great experience, definitely, and I think that's what the minimus thing was, what I learned from it.
One of the questions that I asked when we had the conference in the morning, had to do with the age of the people there, and I was a little bit surprised that I don't know if it was Sean or Linda or Peter said the median age in Billerica was like 34.5, but yet when we were walking around, I thought a lot of the inmates looked very young to me. Maybe that's because I'm old, I don't know. They looked very young to me.
What areas did you walk in?
Well, we
saw yourself.
yeah, we saw
Doctors.
We were in the new part and the old part, meaning that they took us. They took us through everywhere, intake and whatnot. But somebody explained the pod that we first saw. Lily's got her mouth full. I was looking at her for a second.
Well, each pod, I mean, was a really kind of a self-contained unit.
Yes, okay.
And it had a nurse's office where first aid and I assume some degree of medication can be given out.
Explain the main difference between the pod and the newer section that we were in with the older section, if you remember what Frank said.
Well, it's self-contained.
Well, yeah, they were self-contained, but what was the main difference between, other than the old, was really old and grungy and all of that, but in terms of services to the inmates? Now, I may have heard it wrong, but I thought that he said that the inmates in the old section were the inmates that generally said, I don't need you, I don't need anybody, I'm gonna do my time, I'm not availing myself of anything. I think I got that impression, yes?
They were just gonna sleep their time away, so he said something like that.
Are they allowed to do that? Did they try to let an inmate today?
Sure, but remember there was the, there's, the good time behavior, there's the accumulation of, different sort of thing, if you're engaging in things like education and counseling or working on the ward or this and that. So the people, that are not, they don't have to, again, unless it was part of the minimus, as we said before, but you only have to serve your time, unless there's something else, there's some other kind of requirement.
On that
So-
paper that they fill out, as you mentioned it, so if someone got 2 years and
Mhm.
on that minimus,
Mhm.
it listed off 3 things that they.
But that's what Sean was saying, for
Do
the
they
most
have to
part,
do those?
it's saying 2 years. It's not saying the other stuff. What he's saying is it would be helpful to the sheriff's department if in the court, when the minimus is filled in, so to speak, that if they were given more guidance about what to do, or if it became a condition of probation or whatnot. Doesn't always happen. So, that was kind of sad in a way, that was also the old section, so it was like, we don't care about these people, they don't care about us, let's just house them in the older section, which, by the way, the older section even, they used keys, rather than everything electronic in the newer section, and so that was a real, okay. Before we started the domestic violence piece, I also reminded myself that I never talked about the Zelda case. And the reason why I wanted to talk about Zelda, that my partner Ilya, who some of you met that morning, was actually involved in a case with similar issues. Somebody just quickly tell me, and this was the very last case before this section on domestic violence, peer protection of Zelda. If you know briefly what that case was about, so I can tell you about another case that.
I don't have the case here with me because I've brought just the domestic violence stuff, but I believe in that matter, it was a standing issue.
Yes.
The child had, mother seemed to have a lot of children. I think there was 4 children, 4, 6. And some lived with an aunt, some lived with the sister of an aunt or something, and the biological father wanted to get custody. I think she was in foster care. I think they were fostering her. And the foster parents wanted to intervene into the proceedings.
Who were relatives.
Who were.
They were relatives.
Yeah,
Yep.
I think it was the aunt. It was kind of strange the way it was an aunt and an aunt's sister that kind
So,
of had all
so
the
what
kids.
was the standard then,
They didn't have standing. The court said.
No, what was the standard for a judge to allow this type of motion, a motion to intervene? What did the appeals court?
Again, I have all my little notes are scratched in.
Okay.
It's something about the authority. They just didn't have.
No, they have to demonstrate the interest.
And how do you demonstrate the interest, Elisa?
Alina.
Alina, I'm sorry. Alyssa, over here, right? No, Alana. Alana, Alina.
Yeah, it says the
All N's, no
international
S's,
right.
right? Okay.
When a statute of Commonwealth confers an unconditional right to intervene, or when an applicant claims an interest relating to the property or transaction, which is the subject of the action. That was the introduction.
Yeah, where are you
of
reading
right.
from?
I'm
You should
reading
just-
from the case. It's page 200.
And the case refers to what rule?
It's a rule, intervention of rights.
Yeah, where does the rule come from, Lena?
Rules of civil procedure.
Yes, it's Mass Rule of Civil Procedure 24A. So interesting. So care and protection cases, at least quasi-civil in nature, so the rules of civil procedure apply. Later on, when we get to the delinquency and the chintz cases, you'll find that the rules of criminal procedure apply. So the court refers to this 24A, intervention of right, Mass Rule of Civil Procedure. So the intervenor, right, has to demonstrate to the judge, we start to say it.
It has to demonstrate that he or she has an interest relating to the property or transaction which is the subject of the action, and he or she is so situated that the disposition of the action may, as a practical matter, impair or impede his ability to protect that interest, unless the applicant's interest is adequately represented by existing parties.
That last piece is really important.
Yeah.
Unless the applicant's interest is adequately represented by existing parties. So in terms of a care and protection case, what does that really mean?
I thought it was, in this case, the judge said that the interest of a child was already represented by...
No, stop for a second. Who's the
no,
applicant?
No, the interest
Who's
of...
the applicant? Who was the applicant?
Yeah.
Danielle said it.
Father. The father.
No. Who was the applicant in the motion to
the
intervene?
uncle and
The
the relatives.
Who are not parties. The parties to the care and protection case are the children, right? And the parents or the caretakers, etc. So that, in terms of the applicant, read that phrase again, because that's really important.
It's unless the applicant's interest is adequately represented by existing parties.
Adequately represented by existing parties. So because it wasn't, what does that mean? Why were the applicant's interest in Zelda actually adequately represented by existing parties?
They were claiming that they are protecting the interest of a child.
Okay.
And the judge said that the interest of a child was already adequately represented.
So what do you think, how would someone who's, not a party, whether it's, a relative, usually it's gonna be, a relative, a foster parent, a grandparent, right? In what situation, in what circumstances should a judge actually allow a party like that to intervene? If you can envision a circumstance where you would actually be distinguishing the Zelda case. Yeah, you all following me?
In juvenile law?
Yeah. So in a care and protection case, can you think of a circumstance? So Zelda is saying normally we don't do that, right? Because in most of these cases, that whoever that intervenor is, his or her interests are actually adequately represented, whether it's DCF's lawyer or child's lawyer or parent's lawyer. They're on someone's side, right? That intervenor is usually on one of those three sides, part of the triangle, parent, child, state. So the rule is that we don't want you in here, basically. Yeah, you can take care of the kid. And by the way, in terms of, just as an aside, foster parents do not have the same kind of liberty rights that parents do. Famous Supreme Court case offer, and I can't remember the name of it, but they do not have the liberty rights that parents have. All that foster parents have is a contractual relationship with the state, with the department. The department, they're entering into a contract with the department to take care of a child or children temporarily while the parents are unsuitable, unable, etc. So anyway, that's part of sort of this as well. But can anyone answer my question now? Can you think of circumstances, a circumstance where a judge will say, okay, yeah, I'll let you intervene, and you can become a party in this care and protection case, where again, normally you have parents counsel, child counsel, a state, DCF counsel, but I'll let you come in aunt, or I'll let you come in grandparent.
Would it be if the parents is disabled or mentally disabled?
Very good, and that was the case that my partner was involved with. mother was actually mentally ill, and she was off and on mentally ill, if you know what I mean, and had a real off-on relationship with her mother, the grandmother. Grandmother had, and I think either they lived together, mother and grandmother, or at some point did, and grandmother had pretty much had custody of the child from when the child was like 4 years old. But grandmother was seeking to intervene because of the nature of bio mother's, her daughter's, illness, that the daughter would be off and on again with the mother. One day she hated her, didn't want a child with her, another day she loved her, etc. So the court actually allowed the grandmother to intervene in that case and distinguish the Zelda case because the grandmother's interests were not adequately represented by mom and mom's counsel. So it can be done, but it's very rare, you know, for a party like a foster parent or a grandparent to, not that they don't have some kind of rights, especially grandparenting, you know, there's a statute on that by itself. So, you know, that's, I wanted to mention that because we hadn't gone over that particular case.
What happens in a situation where, you know, where there are statutes for grandparents and parents, I think if they hadn't been married or something, or divorced, so what happens if a child's taken into custody?
By the department?
By the department,
Okay.
and put up for adoption, because neither parent, whatever the circumstances, where are the grandparents?
Well, before it comes to that point, taken into custody, so let me sort of use this as a segue into the domestic violence. So suppose that, let's see, how could I segue it? Suppose you have a couple that the husband or let's say boyfriend is severely abusive to the female, and they actually have a child together, and during the period of, I said the child was like 2 years old, and the child has witnessed but not been physically abused by either parent, but has witnessed the abuse between the parents. I'll follow me on this, all right? So we have one, so suppose we had an incident where the police were called to the scene one night because mom was actually severely injured, and the police were going to take dad into custody. Mom was going to have to go to the hospital at that point. And the department, so the police being mandated reporter is going to call the department, and just to review what we did last week, the department, because it's going to be screened in as an emergency, so you can have a worker coming out, right, in that case right away, it's supposed to be within 2 hours, right? And remember the interim report, if it's an emergency, has to come out next day, 24 hours, as well as that the final, the 51B report, I just forgot, yeah, 5 days after that. So anyway, in terms of the 51B. That night, however, the worker also says, you know, okay, this is an emergency, the reasonable cause to believe. Not so much that, again, the child is not physically injured, but the worker, and maybe the worker has been sort of an ongoing person. You know, maybe there have been multiple 51As. Maybe there was, you know, a restraining order at one time or another, but the parties keep coming back together again and so forth. So the worker says reasonable cause to believe this child is in danger of abuse and neglect. You know, not only that, but for now, mom's going to the hospital anyway, so I'm going to take the child into emergency custody right away. So if this is, you know, Tuesday afternoon at 1:30, the worker may know either from previous involvement with the family, or maybe if mom can talk or whatnot, the worker might know that mom's mother, okay, so maternal grandmother, is actually lives in the same town. If you take the child to, you know, say, I said 2 years old, but if you take the child to preschool the next day and whatnot. Besides that, the department is obligated. So remember, under the Code of Mass Regulations, the department has its own regulations. when the department does take a child into custody, and this goes with the whole purpose and policy of the department to strengthen and encourage family life, the department is obligated to, if there are relatives and they're ready, willing, and able, and they pass, qualifications and whatnot, that the department will then place, with relatives. So if it isn't initially, because it might be an emergency and they're just placed in a foster home, the department still has to follow up. Okay. But your question was, if the parties,
If the child goes for adoption.
okay, so suppose in this case, all right, so remember, because it's an emergency and the child is taken custody, the department is gonna go the next business day, so that would be tomorrow, Wednesday, file under 119, section 24, the petition, the care and protection petition, and remember the allegations are the parents are unable at this point, dad's abusive, mom, and mom has more than just this physical injury. It could be that mom, the department is also sort of alleging here, especially if there was a history of involvement, that mom is herself sort of unable to acknowledge the violence that's being done to her, as well as the repercussions, what her child has seen and heard and so forth. So, part of that, as the department files for custody, goes to a 72-hour hearing, granted, so grandmother's the temporary custodian, even though the department has custody, because remember, they can control the place of abode as long as they're not violating their own rules and policies. So they placed adequately with, grandmother, mom and dad might get visitation, etc. But as the case evolves, it looks like certainly that dad is not going to get his act together. Looks like mom is not either, because she's suffering PTSD, etc., that she, takes him back periodically and so forth. So the department at some point changes the goal from reunification to adoption. Right? Want me to vary the scenario so they take the child away from grandmother?
Yeah, well, I'm wondering
Okay.
if grandmother, what if grandmother doesn't live in the state, or what if grandmother is.
Oh, you're really complicating it now.
Well, I'm just like, what if the
Because
grandmother
there's
just can't raise the child full-time custody, and the child gets put up for adoption with a foster family? Will the grandparents have rights?
That's a very good point, because with your, and we haven't gotten to the adoption stuff yet, but you can have a termination of parental rights, but still have an adoption go through where the family, typically it's the parents, but it could be the grandparents as well, have some sort of post-adoption, lack of a word, not really arrangement, post-adoption, I don't even want to say visitation. Sometimes it's just, exchange of, cards and pictures. Sometimes it might be a visit, depending on who that adoptive parent is. So not an easy answer to your question, because it's heart-wrenching, right? Grandmother, that's your blood. But if you're, unable, I had a situation, I had a case, it was a situation where and this was way back when the court, the rules were not as strict about role of counsel. And I actually got appointed in a care and protection case for both parents. It was in the low district court at the time. There was no separate juvenile court. Well, mom was some kind of schizophrenic and was on lithium, but when she was pregnant, she went off her lithium, so she really went crazy. And dad was most of the time okay, but he was bipolar, so that when he was crazy, he was dangerously crazy. When she had the baby was, taken away at birth. Well, as I said, I represented both parents in the care and protection case, but in those days, that was when the department had to go to probate court if they wanted to petition for adoption. when they went to probate court, for some reason they gave me then just the mother, and then they appointed somebody else for the father. What a conflict. That would have been a crazy situation today. But anyway, in that case, there was a grandmother, but she really wasn't, you know, the right person in terms of, and it was really sad because you had two parents that did love their child, because they'd have visitation, and you know, they complied technically to every service plan, you know, but because they were so mentally ill, their fitness really interfered with their unfitness, interfered with the best interest of the child. And were there a relative, grandmother, aunt, whatever, that was willing to sort of help them, you know, and be in the picture and whatnot, they would not have, you know, lost parental rights altogether. But again, in that case, the grandmother was not the proper custodian. She was really unwilling. Bottom line is she was unwilling to take on the responsibility. So if you've got somebody that is willing to do it, and again, that's the department's responsibility anyway, that is a true possibility that that person would become. And they might fall back and end up doing a guardianship instead, with, you know, the unfit parents sort of still in the picture, but the guardian really taking the responsibility, you know, for the child and whatnot. So with that said, something in the facts of the Vaughn case, which was really kind of a landmark. That was a probate case, but it was a landmark case in terms of domestic violence in custody of children. Farina? The Vaughn case? Custody of Vaughn?
Custody of Vaughn? So this was the case which was decided in 1996. It's a Massachusetts case, and I have a copy here. It's the initially a probate and family court judge.
Who was Vaughn?
It was a boy who was 11 years old at that time.
Okay. And who were his parents?
And his parents were Ross, the father's name was, and the mother was Linda, I believe. Leslie. And they were never married. She was divorced, and she had 2 kids from the previous marriages. And
But Vaughn was their child, Leslie and
Vaughn
Ross's.
was their child, yes. And
so what was the issue? What was the real problem there in this case?
it was a domestic violence because Ross was very high-tempered person, and he.
What were some of the things that Ross would do? And I'll come to Leslie in a moment.
He was abusive. And,
How?
There are many ways, and one of the examples which I see here in this copy is like he had Laura, the oldest one of the daughters of Leslie.
He did what? I'm sorry?
He was abusive, and he couldn't control his anger.
Mm-hmm.
And also there is an example in that the Laura then, aged 9 years, yes, she complained that he behaved inappropriately toward her. He
Okay.
kissed her on her mouth and touched her. So she was, then when she testified, she was a graduate student. And
What was it about his, you said violent nature, that directly related to Vaughn's custody? And anybody can answer that. Thought I slowed down with the cases that I
Repeat
gave
that.
you. Why are you all sitting like,
I left my briefs at home, so I'm trying to, I can't write them out, and I left that stack at home instead of leaving the custody, the DSS ones at home.
Norman?
Would you rephrase your question?
yeah,
I mean, he was six.
No, he confused
Oh.
everyone.
Oh, I thought you said you confused everyone, like,
No, Ross, he had a really bad time. He abused everyone, including
Everyone.
Vaughn.
Okay, how?
So
How?
at one time, there was an example in there that was saying that he was yelling at Vaughn and he was poking or prodding him or doing something like that. So one time he hit Leslie to the point where she was unconscious. I mean, that's odd. It's obviously going to affect a kid who sees that kind of stuff. And Leslie also abused Ross.
Okay, but hold that thought for 1 second. Do you wanted to say something, Norm?
Well, I mean, you know, he was
You know, I wanna come back to
6'5",
Leslie,
he was
but-
6'5", 285.
Okay.
I mean, it's like when that, you know, when the sheriff came in, you know, a big guy like that can be overpowering, especially if, I mean, just physically.
Can you also say something about Ross's relationship with Vaughn?
Would, well, and.
What
you
did the
mean-
record reflect about Ross's relationship with Vaughn?
Well, he did a lot of.
Besides him abusing everyone, as Lily said.
Well, I mean, you know,
whatever.
he abused at times Vaughn, but he was also, you know, pretty interested in his, everything he did.
To the extent that what? Give me a sort of drastic.
Oh, it was
Kind of
the
example.
role reversal. You know, somebody, one of the psychologists, I think, you know, referred to it as improper because it was a role reversal. Were we talking about that, or?
Yeah, I'm thinking of a specific sort of.
Did anyone kind of rarely took showers together?
Yes,
Yeah,
yes,
yeah,
yes,
Like,
yes.
like
Is that when you said role reversal, is that what you were thinking of?
No,
Norman, or
no,
something
no,
else?
but I mean,
Yes,
I-
they took showers together,
I
yeah.
thought that was.
At what age, though? I mean, a 4-year-old took the showers, probably.
No, he was
No.
11.
But at 11, he was still doing it.
It was like
They're giving each other massages, yeah.
Yeah.
It's just-
Go ahead, I'm sorry.
Sexually inappropriate.
Norman, you're not finished, right?
No, I mean, I'm ahead of myself.
Yeah.
I'm ahead of myself. What I'm thinking about was when Vaughn started to, you know, feel sorry for his father, or anyway.
What was happening with, where did they live and what work was Leslie doing and what kind of work was, I just forgot his
Leslie
name.
was a
Ross.
real estate
Oh,
broker.
Yeah.
She was a real
She
estate
was a
broker,
broker.
and he was a carpenter.
Okay, so in terms of the,
She was a breadwinner.
caretaking of Vaughn,
She was financially more solid than.
Yeah, he was taken, you know, he was. a
he was
caretaker.
taking care of Vaughn. Okay, so come back to Leslie. What were the sort of negative things about Leslie that the court also brought up in terms of the domestic violence issues? Elizabeth?
What was that again?
What were the negative things about Leslie that the court noted in terms of the domestic violence issues?
Well, Lily touched on it a little bit, was that she provoked some of Ross's
According to,
actions.
what do you think about that? In terms of what you've read about domestic violence in general? Let me ask this question. If there's a typical or characteristics of, let me do the word characteristics rather than typical. What are some characteristics of an abuser, characteristics of abused victim, and then later on characteristics of children who witness? So let's talk about the person who is abused, like Leslie.
There's a lot of denial, I think.
Okay.
They're also, there's different levels of when they're in their scared space, and then there's the different levels as to when they're, you know, in a comfortable spot, because the abuser tends to flip-flop himself back and forth from being
Or
overpowering.
herself, because remember, it could run
Right.
both ways.
Right, or herself, from being overpowering and then
Or it could be same sex too.
Yeah, or to the point of them feeling bad for what they did. So during that feeling bad point, you sometimes see the abused victim using that, and I also think the abused victims sometimes feel that if they're not at them, then they're not loving them, or their attention's somewhere else. So I think they kind of blamed Leslie's behavior on the fact that she was abused, and that was kind of her coming back. But I think maybe she needs to be at him to be getting that negative attention.
There are two general theories. One comes from Dr. Lenore Walker, and I'm sure maybe some of you have heard about her, and that's more like the cycle theory, that the there's a period of time that is sort of the slow or fast escalation of hostility that results in, violence towards an abused victim. And then the violent episode can become, quite violent. In fact, the person could be in a lot of danger and could be killed, could sustain serious injuries and whatnot. So there's the escalation, then there's the violence, then there's what's called the honeymoon period. Oh, I'm so sorry, I'll bring you roses, I won't do it again, and I really love you, blah, blah, blah. And so that's the honeymoon stage, and then, that sort of, erodes after a while, it comes back to the escalation, so it's like a circle. Another theory, and I don't know where this one comes from, it's more like, for anything, rather than a circle, it's more like a line, that the abuser is really always in control, always in control. Even when there's no, physical abuse going on, there's always the fear, the intimidation, the use of threats, the isolation, the financial as well, if that's the case, the using children and so forth. So it's sort of like an always control period. But what both theories also believe, and it's evidenced by statistics, that the abused victim is actually in the most danger when that person tries to extricate herself or himself from the situation by I'm leaving, I'm getting a divorce, I'm getting a restraining order. So that, in fact, the abused victim thinks that he or she also feels in some sort of control in terms of I know what to do so that I don't get hit, or I don't get hit as much. Or I may even cause it just so I could have the honeymoon period after, not always consciously. So getting back to the typical characteristics, especially, there was right around the time, actually Vaughn mentions the gender bias study. At the time, the court underwent this huge study of, gender bias in terms of custody situations. And what would happen typically is that, and I'm going to have to use the man-woman thing now because it was a gender bias study, that when parties went for custody, whether it was in a divorce situation or any type of situation, it was more typical that the male actually would get custody, even when the male was an abuser. And that's because it goes back to that whole control issue. It's the male that would come across, to the court, to interested parties, to the judge, probation, the attorneys, and so forth, would come across very well. He tended to be, the one that also had the job, dressed nice, etc. Tended to be more well-spoken because, again, that person's in control. Whereas the woman, the abused victim, came across and was really crazy because that person's suffering from PTSD. Came across crazy, emotional, volatile, violent at times. So it was quite typical that the SJC would pick on poor Leslie, I'm sorry, for her negative sort of behavior. As Norm pointed out, Ross was the big guy, but yet the court commented that she was also abusive as well. But it was a pretty good commentary and a step forward in the area of domestic violence as a result of that case. And I don't know the codification of the statute, but it's somewhere in 208 because it's in the divorce statute, that if a probate court judge today is going to award any kind of custody to a person that's had a history of abuse, there has to be, specific findings of fact, and they really have to pay attention.
Is that the one with the restraining order they talk about in
Yes.
section 31?
Yeah. 208-31,
Yeah.
right? Okay, thank you. It's 208-31. Oh, it was mentioned in Vaughn itself?
Yeah.
All right, so the statute came first and then Vaughn, it was around the same time. Okay. So that's basically the the Vaughn case. And again, it's interesting that there are really very few when I say domestic violence case, case law, appeals court or SJC cases, dealing with restraining orders or domestic abuse. Why do you think?
Well, a lot of people don't have the courage to go file for a restraining order through 9A. They feel
And
intimidated.
it cuts across all classes. And typically when you say don't have the courage, some, women or men who are of higher means, they may go and get, counseling, medical help, et cetera, on their own, and for lack of a better word, don't have the courage to be out in the open, hey, I'm getting a restraining order, right?
And it is a nerve-wracking experience. I think it's extremely stressful for people going to file because you could be waiting in the courtroom for a couple hours before. Usually, some judges do it differently, but I've seen judges wait to do 209As until like
Later in the afternoon,
until
or
arraignment. So you could be waiting in the court all day just to get a stay-away order against your crazy ex-boyfriend.
Yeah, and I remember, I want to say it was either the 80s or early 90s, and I think his name was Judge King, like Somerville or somewhere like that, that really put a woman really on the spot, who was ultimately actually killed. I think he wouldn't order the restraining, it had to do with the restraining order. So you had, and still have a little bit, or maybe a lot, in the system, when I say the system, from judges on down, people that poo-poo it away, that, what's the big deal, right?
I will say though, I give a lot of credit to the victim witness advocates.
You say that again?
I give a lot of credit to the victim witness advocates in the district attorney's offices. The services that they offer.
Could you
are
explain what the
unbelievable.
victim witness advocates do? Because I know you were involved with the district attorney's office a little bit.
Yes, so there's this law, it's, let me find it here. The Victim Bill of Rights
Yep.
that was enacted in '98. And so victim witness advocates are basically available for women or men at all times throughout court proceedings to kind of come up with.
In any case, not just domestic violence, any victim can avail themselves.
To kind of come up with an action plan and also to keep you informed along the whole proceeding of what's going on, and to also just offer like some social services as well. I think the biggest thing that victim witness advocates do a great job of is being with the victims throughout the whole process in the courtroom, staying with them by their side, helping, and then also staying in between like the victim and the perpetrator throughout the court proceedings, and then keeping everything confidential. I think the biggest thing like the Victim Bill of Rights says is you have the right to be informed about the criminal case, how it progresses through the court, know your role, what's expected of you. And that's just essential for someone that's never even been through the legal system, or someone that has, that's clueless. You have someone that's a professional that's working with you to help you make this process a little bit easier.
Right.
Do you need to get special education? Do you need to be certified to become one?
I know
They
that-
have some kind of training, Marina, but I'm not sure exactly.
I know that there's a few
volunteer
students.
I'm sorry?
Aren't a lot of them volunteers?
They usually are paid through the
They're
DA's
paid
office.
positions, but
Yeah.
you might have interns or people volunteering a lot in that department.
We have a few students that work at the
Yeah,
that
yeah,
work as
we do.
victim witness advocates. But I mean, this Victim Bill of Rights is just great. It's MGL chapter 258B.
Thank you. Did you all read the Guardian ad litem report that I gave you? I'm going to tell you a little bit about the background of that case. I was actually the Guardian ad litem in that case. And I think it was probably around that time, and probably with that case, when I realized that domestic violence, or whatever you want to call it, isn't just physical. And you might say, yeah, sure, I know that, but it was sort of like it was at the time an epiphany, for, again, judges and other people in the system. Domestic violence was thought of as, some person that's bruised and beaten and battered by another. In this particular case, while the father might have had some physical altercations with his ex-wife, later on his girlfriend, for the most part, his was all a mental, emotional sort of battering that went on. And his was the typical case, like when I explained before those two theories of domestic violence, his was certainly the straight line. It was always the control. Can't remember if I mentioned it in the report, but I remember the older girl who was only at the time, you guys just read it. How old was the older girl?
She was, they were 8 and
yeah, so she was only 8 when
8
I
and 11.
started? Oh, 11, yeah.
Yeah.
Okay. Said to me something like, my dad, when he's not in control, he's out of control. And I was like, wow, this 11-year-old just really hit it on the head. When he's not in control, he's out of control. And he had, I remember when I first met the parties and started my investigation, blah, 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 he had a loose leaf binder. That's the first thing that I noticed. He was impeccably dressed in a suit, and the binder had like all the pleadings and tabbed it. You know what I'm saying, all right? And custody was always back and forth. This case was crazy with more issues than are noted in that report. But one of the times that he had custody and I went to the house, he had like this elaborate calendar that accounted for sort of every moment of the children's time. And again, if you don't really know, you say, oh, that's nice, because, he's making sure the children do the chores and whatnot. But again, just sort of like a small indicator of this sort of elaborate sort of control. When we would talk about, now again, I'm guardian ad litem for something in best interest of the child. So when I interviewed the parties, and mom, with all her craziness, and she was crazy, seems to be thinking about the kids. So it's always, she starts her sentences with the kids, not my. And yet dad is my. My children. I want, I need. So then again, a few, those were just some of the things that, brought me to the conclusion that I don't see bruises, but this guy's a batterer. I see children that have really suffered as a result of living with the two parents, because you had the young child then began to emulate and imitate the mother's behavior. Not so dominant, let me please you, let me look pretty, and the older child, belligerent, also kind of out of control and whatnot. And I sent him this to Story. I got a call earlier this year, and she's like 30 years old, I swear. And she said to me, you saved our lives. I'm like, what? What did I do? She says, you don't understand. You were like the buffer. You were the buffer between us, our parents, the court system, and everything crazy that was going on with us. So that was nice to know. Has a child, will never get married. So there were, obviously repercussions and effects on this child that has become an adult. So Thursday we're going to start child sexual abuse, another serious issue. By the way, there's a relationship, if you haven't thought about this or seen this in cases, there is a relationship between DV, domestic violence, and CSA, child sexual abuse. You sometimes see both of those issues in a home. Because again, what are they really both about? Control, power, etc. I'm going to be passing out this, it's an older case, and I redacted as much as I could from this case. It's very serious. All the cases are serious, but it depicts, there's some pretty strong language about the sexual activity alleged, but whatever, between the father and the children. So again, it's obviously an educational experience, but I also think of you as, you're all attorneys, would-be attorneys, so whatever I would keep this privileged material, even though I think I've gotten rid of most of the identifying material, and it's also many years later. So what I want to be doing is actually, when we start child sexual abuse on Thursday, I'd like you to read through this packet. And as soon as it goes around, I just want to identify some of the documents in the packet so it can make some sense to you. Let me just make sure everybody has one. And for the people online, I'm actually going to, or Ashley, who isn't here, I will put copies outside my door. I think Ashley's the only one missing, right? Yeah.
I'm in class with some of the online students, so I tell them to go out to the
Yeah, so there's a little table outside my office. Actually, the table outside my office contains, did you all get what I sent you electronically, the power control wheel? It looks up, what else is on that? Was it just that? Power control wheel and the characteristics?
Of the behaviors and definitions.
Yeah. I sent that, when did I send that? Last week. There are hard copies of that outside my office. So outside my office is the power and control wheel that, again, I sent electronically. Why do you happen?
You sent me something yesterday afternoon, and I'm reading it, I'm like,
What did I
what
send
does
you
this have
yesterday?
anything to do with juvenile law, but it's for my writing class? So I'm sitting there reading this going, what is she doing?
Oh, arguing motions.
But
Is that what you were just, I sent you
it's in
arguing motions?
Yes.
Yeah,
And I'm
no.
reading it going, are we gonna be role-playing domestic violence in class? Sorry, I just remembered that as you were talking to me.
So anyway, if it's not on your email, if you want to grab a hard copy, that's outside my office. And then again, this child sexual abuse class assignment. I just want you to, we'll talk about these roles later on, but if you would turn the page, the first thing that you'll see in terms of documents is the criminal investigation report by the police department. And that's the first 2 pages. So again, it's a whole case 87, all right? After that is the 51A, the child abuse and neglect report form. And there are 3 children, Alicia, Jason. It says unknown, but at the time they didn't know Jonathan, the little boy's name. So that was that. And notice that on the 3rd page of that, where am I? Where there's screening, family narrative. No, wait a minute, that isn't what I want. What did I want to point out? Hold on. There's somewhere where it says emergency. No. Hold on. Child abuse and neglect report form. Alicia Jason, unknown. Okay. Turn to the next page. Lee, he's the father. Page after that, information on the reporter, mandated. Then there's a family narrative. Turn to the next page, the end of the narrative. The page, and the page after that, this is really interesting, because the box that was checked off said screened in, no emergency response required. Well, I puzzled over that for years, because they did go out right away, so they treated it like an emergency. So at the time, maybe they thought there was no emergency response, but they found out the dad was actually in court being arraigned on the rape of a neighbor, and that's why they went to the house right away to interview his children. So it should have been emergency anyway. After that is a medical form that shows Jonathan and Alicia. And after that, there's a document that just has a date at the top, 4/21/87, and it starts worker met Kathy. Everybody with me, Daniel? Yeah. Social worker notes. Those are social worker notes. 1, 2, 3, 4. I'm just counting the pages. 5. Those 5 pages are pages, again, excerpts from the social worker's notes on both 4/21 and the next day, 4/22. After that, there's a document that says Commonwealth of Mass, Executive Office of Human Services, Department of Social Services. This is remember when I went over the procedures of 119 and I said in the more serious cases, the district attorney gets notified? That's exactly what this is. A notice, referral to district attorney, checked off, child has been raped. Second page. The third page of that notes that the service plan is also going to be sent to the district attorney's office. After that are some of the documents from the court. The emergency temporary order of custody for Alicia. The next one, same thing for Jason. The next one, same thing for Jonathan. Those were dated April 22nd. And guess what we have next? A minimus. Now you all know what it would look like, I guess, also in those days for care and protection case.
So you pronounce it as minimus, even though it says minimus?
Minimus. Minimus.
Minimus?
Minimus.
Minimus.
Minimus. How would you pronounce it, Lena?
I don't know.
Minimus. Mit. So we've got Jonathan, and then this is back in after that in May, and it says keep him until June 29th. So it's saying when to bring the case back to court, basically. Again, for Jonathan, Jason, Alicia, the 3 children. Then a document that's MSPCC. This is the court-appointed investigators report. Notice it's dated June 24th. So remember, this case started in April. So up until that time, the investigator was doing her investigating, and then ended up, writing this this report. And it's 1, 2, 3, 4, 5, 6, 7 pages with the summary at the end. And then there's an updated one, same thing, same reporter, June 29th. That's a couple of pages long. And I just started throwing in, and I didn't have all the, just to show you that another examples of a minimus with a continuation in August. The case went on much longer than that, but I just wanted to put together some documents to give you guys a feel, not only for the case, but for the interrelation and conflict between the care and protection case involving Lee's children, as well as the prosecution of Lee. And you'll get more familiar with this, but basically Lee was prosecuted initially for allegedly raping a friend of Jason's, a neighbor, but then he ultimately also gets prosecuted for the sexual molestation of his own children. So after reading the cases that you'll start for this Thursday, we're going to do a little role-playing thing. I want to do it next Tuesday if we can. I will not be here next Thursday. What date is next Thursday? The 24th. I have a really good, again, the old videotape of dealing with child sexual abuse. It's interesting. Of course, I'm on it because it's an MSL TV show, but and I'm much younger. Oh God! So I'm glad I won't be watching it. I want to put it on reserve in the library. And it's interesting, Norman. You met Tom Malone, who's now at DCF. Oh well, was back then. He's actually on this videotape, and I hadn't seen him since that MSL TV show. How long ago was that? And now he's up here in this region, and he's a wonderful, great DCF attorney. Judith Wolf is also on that. By the way, Judith, I gave you guys the Isaac and Jeremy cases. She was the attorney for one of the parents in one of those cases. And those were the cases that, again, held that, in terms of the separation of powers, basically, if DCF has custody, DCF has the right to do everything unless DCF is abusing its discretion, acting arbitrarily, capriciously, et cetera. So Judith becomes sort of the stand-up, who was on it too? Anyway, we talk about this case on that tape. It might have been on, I don't remember. So I think what I'm gonna do, and I'll talk to you more about it, is I'll probably leave that videotape, a few copies of it at the library desk. I'll ask you to watch it, and then, you know, we'll talk about it in class the next time I see you or whatnot. So we won't actually have a class a week from Thursday.
Can we watch it in the library, and we take it home?
Well, I don't know how many copies they have.
Can we just run it up here at class time?
Yeah, because no one will be here at 1 o'clock. You can all sit, and, you know, have your
that?
lunch or
That
whatever.
sounds good. We'll just
and
grab the tape and
just
run it
whoever
there.
wants, you know, that way you're done and you watch it together and, you know.
We're gonna have to make sure the TV, this
That's
isn't
not
always.
fair, you're gonna have a party without me.
This isn't always here, Dan brings up for the class we have
Okay.
right before this.
Okay. Well, you can walk around and find one.
Okay.
Um,
Okay.
Right
We'll
after
just watch
the,
it.
yeah.
Okay.
Find, especially around 12, 12:30 when there are no classes, you can just poke your head in the classrooms.
Okay.
And find them. Any questions up till now about any of the procedures that I talked about with 119 and 210, which we'll go over that more with the adoption cases. So this is what I want to do. Let me think now. For Thursday, you've got some cases that are a mixture of criminal and civil. And the remainder of them for the following Tuesday, which is the day that I want to do this. So that means by next Tuesday, the 22nd, I would like you to have read, you know, all of them so that you could really play, you know, a good role. Do I want to assign you guys these roles now, or would you rather wait and read the sexual abuse stuff and give me an idea on Thursday what you want to, because I'm going to need, as you can see, DCF attorney, district attorney, blah, blah, blah. You want to wait and read the packet first and then
So
decide
you
on
want us to
Thursday?
read this for Thursday and then this and the other
What's
one?
this and this? Well, the online students and the
Yeah.
rest of
Oh,
us
sorry.
that can't see what
So
you're pointing to.
for this Thursday,
Yeah.
you want us to read the case you just handed us out?
No, the
Packet.
packet, and then the case is up through.
Yeah, certainly, you've got to read the
Cases
case
for
I've handed
Thursday.
out, because I want to be talking about it
On Thursday.
while we're, you know, dealing with these leading cases. And so, I just want to say there's sort of a few categories of cases that you've got here. So you've got, in your care and protection cases that are child sexual abuse are always going to deal with a case where the perpetrator is a caretaker, you know, a father, a mother, some kind of caretaker. A lot of the criminal cases typically are cases where the perpetrator is someone else, not a caretaker. The lead case, the real case that I gave you guys to read is both. The perpetrator's the father in the care and protection case. He's also the defendant in the criminal case. There's a statute.
But he's not an actual father, right?
Yes.
She was married to another guy and had two kids.
Yeah, he's not the biological, but he's still a caretaker.
Okay.
He's the father in essence in terms of they lived with their quote adoptive dad or pre-adoptive dad, yes. There's a statute, 233, 81, 82, 83, that deals with out-of-court statements of children under 10 who are involved in sexual abuse by their caretaker. When I say the three sections, 81 deals with, and I might be saying it backwards, but 81 deals with criminal, so out-of-court statements of children under 10, if they're going to be allowed in criminal proceedings. And just think about what a criminal proceeding is in terms of the defendant's liberty rights and due process rights. It's much harder to get them in, so there are more hoops that you have to jump through if you're the proponent of getting those statements in. 82 deals with your, quote, civil cases, and those would be your adoption cases, your divorce cases. So again, still not as hard as the criminal cases, but still there's some hoops you're gonna jump through. 83 are your care and protection cases, and it becomes then the easiest sort of for the proponent to get those statements in. I think I gave you that statute. Remember that your statutes are in the addendum at the end. So take a look at those. They're certainly mentioned in Commonwealth v. Collin. And where's the other one? Rebecca and Quentin. So those 3 cases that you're gonna read for Thursday deal with the statute. Deal with the statute. Now, before the statute was enacted, there was really no way, you know, other than the victim testifying, some direct physical evidence. What's really scary, lack of a better word, about these cases is that cases of child sexual abuse, that many, many, many times, I can't stress the many enough, it's only the abuser and the victim that really know what happened. That really know what happened. So if the victim isn't going to be testifying because of trauma, because of I don't want to do this to daddy, etc., then the department or the DA's office really has nothing, no evidence. So those are the types of cases, again, that you'll be reading for Thursday and then for the following Tuesday. And we'll also, you know, another issue in this case, in these cases, also deals with role of counsel, especially when you have, in this case, the older children, Jason and Alicia, right after they made their initial disclosures to the police and the social worker that went out to investigate and talk to them, immediately recanted what they had said earlier. And their position was, through their attorney, that they wanted to remain with their father. So you had a real plan, especially in those days in the 80s when, you know, really attorneys for children were just sort of beginning to be out there and making waves, so to speak. So the department was saying, you know, what is children's attorney doing here? You know, we sent the kids down to talk to the district attorney's office, and children's attorney yanked them away and said they're not talking. So the judge then appointed me as a guardian ad litem because it was conflict between what the children want, what they're saying they want and desire, versus what might be their best interest. Massachusetts is a client for children. Massachusetts is what's called a client-directed model, meaning that if you represent a child, no matter how young, 1 day old, you have to determine what that child would want or need or desire in this litigation. If he or she were old enough, mature enough, know about proceedings, etc. What you don't do as counsel for the child is say, I'm going to be this child's champion, and I think what's best is blah, blah, blah. That's a guardian ad litem model, and many judges appoint a guardian ad litem anyway, although there's no money for them today, so I have no idea what's going on with that. Some states are just guardian ad litems, so we're truly sort of an advocacy sort of state. If you're taking these cases as appointed counsel and getting paid, at least for now, by the state, with everything that's going on, the Committee for Public Counsel has guidelines of representation, and that's exactly what the guidelines dictate. Even when you represent, say, you know, a young child in a care and protection case, one of the things that you have to do is go out and visit that child. We know an attorney, and I think, Norm, we talked about him. We won't mention his name, though a nice guy like him, advocate in all other respects, but an older guy that said, why should I go visit my 1 month old client? This, what? There's no reason to. So CPCS took him off the list. That's the requirement. You see the child in his or her surroundings. Yes, the child can talk to you, but by sort of getting the whole picture, you should be able to determine, you know, what your trial strategy as counsel for that child should be, would be, etc. So also, you know, part of your continuing legal education in this as an attorney is not only learning the updates on the statute and the case law and whatnot, but it involves the other disciplines, you know, developmental, you know, biology, psychology, mental illness, competence, etc. So then you can, you know, be a better child's counsel as a result, parents' counsel for that matter, and state's counsel as well. It's a true specialty. And it's taken, I'm really getting on the soapbox now, but it's taken the bar advocates that I know a long time to specialize in this area. And the governor is looking to take that away and you know, put in young, not necessarily young, but people that may not be as specialized in the area and pay them less and whatnot. But anyway, that's not part of this class, so sorry, I got the soapbox on that.
I just want to ask one question, if you're gonna find that if, I don't know really exactly what he's trying to do. I thought he was gonna try to get rid of the CPCS and more go with hired attorneys for those.
But that's exactly what that is.
How
That's
is that
exactly.
gonna even backlog? I mean, you imagine all of the people that are there representing the children now, don't you think they're just gonna become more of a number? You know, like, those attorneys aren't gonna be able to handle all of that work, would they?
I don't know.
Yeah, I think it'll get to a point, you know, where it's that old adage, you know, if it ain't broke, don't fix it. Well, at some point, you know, they're gonna realize if it changes that, you know, it'll break. I mean, there'll be kids that will certainly not necessarily be denied services, but will come up short.
That's what I believe too.
Or just, you know,
Waiting,
or
just
they'll
waiting
wait,
their turn.
they'll wait until, you know, something bad happens. You know, usually change takes place after, you know, a plane has to crash before the FAA, you know, changes things, and so.
So anyway, I don't know where the government's proposal is in terms of the plan, but that is the plan. Whether it's gonna happen or not, who knows, but, anyway. So read through the packet, read through the cases for for Thursday, and then by next Tuesday, you're going to have read everything, but we'll do this role-playing exercise on next Tuesday. Next Tuesday. Yeah, thank you.
We'll read what's on here Tuesday, in the packet.